Friends, this is an unprecedented moment in our constitutional history. For the first time since the War of 1812, the US Capitol has been attacked by an armed mob, and the House of Representatives is on the verge of voting to impeach President Trump for the second time, which would be the first such double impeachment in American history. What I think we need to remind ourselves of is that the vision of armed mobs incited by demagogues to assault the rule of law was precisely the evil that the founders of the Constitution were determined to avoid. Remember when we talked together about Shays' Rebellion, about those farmers in Western Massachusetts who took up arms to attack federal courthouses because they did not want to pay their debts? It was that vision that persuaded the Continental Congress to summon a constitutional convention to come to Philadelphia to revise the articles. And it was the vision of how democracies fall when they are inflamed by demagogues and mobs that James Madison had in mind in the summer before 1787, when he read 2 trunkfuls of books that Thomas Jefferson had sent from Paris about the failed democracies of Greece and Rome. Remember that quotation from Federalist 55 of Madison? In all large assemblies of any number composed, passion never fails to wrest the scepter from reason. Even if every Athenian had been Socrates, Athens would still have been a mob. So that fear of mobs, of violent groups of people animated by passion, by which they meant violent and turbulent emotion, rather than reason, by which they meant self-restraint and deliberation, was what the whole Constitution was set up to avoid. And you know that this class is entirely nonpartisan. We can only say things that are historically grounded and make sense in context, but I can share with you, because we're sharing this important moment in constitutional history together, that we're living through a challenge to our constitutional democracy, such as none of us has ever seen before in our lifetime. So far, the Constitution is carrying us through. We had a very inspiring podcast last week with Dean Erwin Chemerinsky, who's the Dean of the University of California at Berkeley Law School, and Judge Michael Ludig, a very distinguished former conservative judge. And they both agreed that in the face of this unprecedented threat, the Constitution is prevailing. Congress resisted efforts to overturn the electoral votes in the face of false claims of fraud. State election officials accurately certified the results, and judges uniformly rejected baseless challenges to the integrity of the election. And ever since that, members of both parties have denounced the insurrectionist violence that we saw on January 6th. Now, what happens next, we'll see. The House, as we speak, is deciding whether to impeach. If they do so, this might be the first time in American history that the Senate takes up the articles of impeachment after the new president has already taken office on January 20th. You know that the impeachment clause provides not only for removal from office, but also from disqualification to hold any future office of honor or trust under the United States. So that would be a penalty that the new Senate might decide to go ahead with, although it's not clear from the text of the Constitution whether a post-term presidential impeachment is contemplated. There's nothing in the text that prohibits it, and there was a federal official who was impeached in the 19th century but tried after he left office. We can have a debate about whether or not the text allows it, but in practice, it may well occur, and the Senate can make its own precedents in the face of unprecedented threats. And the US Supreme Court is unlikely to intervene, although it's not inconceivable that they would about whether or not the post-impeachment trial is is okay. So I'll just stop there, and we'll look at your chat because I want to see your reactions.
Yeah.
Before we move on.
One question that within the chat that came from Audrey is, how long does an impeachment process take? And I know it seems to many students that it is something that would take a very long time. So is there any kind of time around it? How long it takes? Gloria asked the question of, does this stop unity? Can this bring us at odds even more? I think these are great questions, so I wanted to pull them out. Yeah, that's the two big questions from the chat.
Yes, and Warren on the 25th Amendment, indeed. How long does it take? It could take a day. We had the articles presented to Congress today. They're published. You can find them online. We can read them. I think perhaps we should, because they're pretty important. And Congress might vote on Wednesday. So now remember, impeachment is two phases. An impeachment, like a grand jury indictment, is the House saying that we indict or impeach the president. A trial in the Senate takes longer. There are rules. Leader McConnell has said that it would be impossible to convene the Senate as an impeachment trial until after January 20th. And we saw the last impeachment of President Trump took, what was it, a couple of days, 4 or 5 days in the Senate. So the trial might take a bit longer, but that's how long it takes. It does not promote unity for the second impeachment, bring Americans together. That's the argument against it. And indeed, I think that's why Leader Pelosi said she'd prefer resignation under the 25th, removal under the 25th Amendment, suggesting that she, for what it's worth, is less focused on disqualification from future office holding than just getting the president out, because she considers him a clear and present danger to American security. Others have suggested censure, which is by the House, as an alternative to impeachment. And President-elect Biden has said it's up to Congress, suggesting he's not going to tell Congress what to do. So that's the argument against a second impeachment. And the 25th Amendment, there's a lot to say, except just in practice, it doesn't seem very likely to happen. Because remember the mechanism, the vice president and a majority of the cabinet have to certify that the president is unable to discharge the duties of his office. And this vice president has suggested that he's not inclined to do it, although he hasn't totally taken it off the table. And then you need a majority of the cabinet or the principal officers. There's a question of who's the principal officer, because a bunch of cabinet officers have resigned. Is it a majority of the sitting ones, or are the acting secretaries principal officers? Hard to say. There's a Supreme Court case called Mistretta, which suggests that one case says the principal officers have to be Senate confirmed. Another case says that they don't. In practice, the Supreme Court's not going to second guess it. But again, things are, there's just a week and a half left. What makes the 25th Amendment harder to stick is that if the vice president and a majority of the cabinet say the president's disabled, the president can object, and he can say, no, I'm able to discharge the duties of my office. And then Congress has something like 4 days to vote about whether or not to keep the president out. And you need 2/3 of both houses of Congress to keep him out. So that's an even higher threshold than impeachment, which just requires a majority of the House and 2/3 in the Senate. All that is unlikely to transpire in a week and a half. So that is why the 25th Amendment seems less likely to be mobilized.
Okay, 2 more quick questions on this. So if the current president is not impeached, in 4 years could run for president again, correct?
Correct. If he is impeached, then he could be forbidden as part of the penalty from running again. And holding any office of honor or profit under the United States means not only that he could not run for any federal office again, it also means he would lose his status as a former president of the United States, with it the Secret Service protection, the pension, the travel allowance, all of the honors and duties of and privileges of the office would be stripped from him. Although it takes a 2/3 vote to convict someone of an impeachable offense in the Senate, you only need a majority to impose the penalty of disqualification to hold future office. Now, in practice, if there was 2/3 vote to convict, probably there'd be a majority to strip him of the future office holding. But yes, Audrey, if the president is not impeached and not disqualified from holding future office, then he could run again.
Got it. And one question that we got on Twitter and in our education email box is around 14th Amendment Section 3. And so have you heard that come up yet? Sorry, as we have this current events, there's so many parts of the Constitution people are looking at to say, how is this working? Is this going to come into play? So you want to throw that one at you.
Yes, I was last Wednesday commenting on this remarkable event, and our friend Colin Thibault, who is often in this class, emailed me about Section 3 of the 14th Amendment while I was doing the commentary, and was able, thanks Colin, because I was able to call it out and its significance, and it's proved to be very significant because it's cited in the articles of impeachment that the House issued today. So let's read first from the articles of impeachment. The House said, and I guess I could screen share, but I'll just, in the interest of time, just read it. Article 1, incitement of insurrection. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that the president shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Further, Section 3 of the 14th Amendment to the Constitution prohibits any person who has engaged in insurrection or rebellion against the United States from holding any office under the United States. In his conduct while President of the United States, Donald J. Trump engaged in high crimes and misdemeanors by inciting violence against the government of the United States. In that, and then there's a statement of facts about why the impeachment articles believe that the president incited insurrection. It's really striking that the framers of this impeachment article cited Section 3 of the 14th Amendment. Let's now read all of Section 3 of the 14th Amendment. Here we go. Because this also could be relevant whether or not the president is impeached. Congress might choose to pass a law disqualifying him from holding office under Section 3 of the 14th Amendment. And the question is, could they do that? So let's read that. Section 3 says, no person shall be a senator or representative in Congress, or elector of president or vice president, or hold any office, civil or military, under the United States or any state. So if the president is covered, it would have to be under that clause that says, or hold any office under the United States, because he's not a senator or representative or presidential elector, who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state. I'm going to stop again and say, if the president is covered, it would have to mean that he took an oath as an officer of the United States to support the Constitution of the United States. This is a long sentence, but it's basically saying you can't be an officer of the United States if you've taken an oath as an officer of the United States to support the Constitution of the United States and shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So this section was intended to ensure that former Confederate sympathizers who, having sworn to support the US Constitution, nevertheless engaged in insurrection or rebellion against the same, or gave aid and comfort to the Confederacy, couldn't be a senator, representative, presidential elector, or hold any office under the United States. And then, but Congress can remove the disability. So a bunch of questions here. First, is the president covered? Obviously, this wasn't what the people were thinking about, because it was the Civil War and the president was not in open rebellion against the United States, although, Andrew Johnson's conduct was questioned. He wasn't said to have given aid or comfort to the enemies of the United States. But Congress appears in the articles of impeachment to have judged that the president is an officer of the United States and who has taken an oath to support the Constitution and therefore is covered by this article. And then the question is, how do you enforce this? It says that Congress can, by a 2/3 vote of each house, can remove the disability, suggesting you don't need presentment to the president. In other words, you don't have to pass a bill removing the disability that the president signs. Just by a 2/3 vote, Congress could say about an individual, you are allowed to serve. But the question is, would you need a bill signed by the president to disable President Trump from holding any office of civil or military under the United States? And the answer to that seems to be Section 5 of the amendment, which says the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Section 5 is the enforcement clause of the 14th Amendment. Generally, Congress has to pass laws that are signed by the president if you want to enforce the equal protection guarantees of the 14th Amendment. That's the basis for the Civil Rights Act of 1965, which we studied, or the the Civil Rights Act of 64, the Voting Rights Act of 65. All of those are federal laws passed by Congress and signed by the president as part of Congress's Section 5 authority. So my quick reading of this, and I have not studied the precedents or heard the arguments on all sides, and if any of you is inclined to dig into this history and write a memo about whether or not you think that this clause, Article Section 3 of the 14th Amendment, does or does not apply to the president and how the Congress would enforce it, and send it to me and Curry. We will be glad to see it, and we'll try to send some thoughts back. But my textual reading is that Congress would enforce it by passing a law that would have to be signed by President Biden if President Trump were to be disqualified from holding future office under Section 3 of the 14th Amendment. But this section was part of the articles of impeachment that was designed to support the case that this president violated the Constitution when he incited armed insurrection against the United States. There's some great more comments. Larry Johnson says, if I may, when an order or crime goes into a courtroom, the person or persons have a right to file an answer to the charge. This is an action to buy more time and find a loophole. Absolutely right, Larry. An impeachment proceeding doesn't give the president a chance to file a response. In that sense, it's like a grand jury indictment. When you're indicted by a grand jury, you don't have a chance to present your side of the case. It's a totally lopsided affair where the prosecutor presents only the state's evidence, doesn't have to present a lot of competing evidence. That's why the truism is that a prosecutor can convince a grand jury to indict a ham sandwich because it's a one-sided affair. The president gets to put on his side in the impeachment trial of the Senate, and that's when that generally occurs. But the other thing that's really important is the question of whether President Trump met the legal standards for incitement during his speech on the ellipse, where, according to the articles of impeachment, he said, and I'm quoting again from the language of the indictment, which I just lost, but I had a moment ago. Essentially, the indictment quotes the language where the president said, we've got to take back this country, we've got to fight, and also said that the election was stolen. The question of whether that language meets the test for incitement, which comes from the 1969 Brandenburg case, which says that in order to be unprotected speech and illegal incitement, the speech has to be intended to and likely to cause imminent violence. Intended to and likely to cause imminent violence. The Brandenburg case was one where a member of the Ku Klux Klan stood up in front of a Klan rally and said, unless there's some change in this country, white people are going to have to take revengeance. It was racist, appalling speech, hateful speech. But nevertheless, the US Supreme Court protected it, saying it was an expression of opinion. It was not intended to incite imminent violence. It was a Klan rally where the members of the audience weren't told go march against African-American people. It was just like a political rally. Not just like but it was a political rally, and it was not likely to cause imminent violence under those circumstances. So that's how rigorous the incitement standard is, and that's why some scholars, including Alan Dershowitz, who was one of President Trump's lawyers in the first impeachment trial, said, regardless of what you think of the president's speech, and I deplore it, it did not meet the legal standards for incitement. Twitter, when it banned the president, found that his speech was inciting, But Twitter is not bound by the First Amendment and was not applying the Brandenburg Standard. It was a more general notion that the speech would have a tendency to incite violence. It's a more relaxed standard. And reading the Twitter statement about why Twitter concluded that the president's speech was inciting is interesting. It's a thoughtful 2-paragraph statement, but it's nothing like a fully fledged judicial opinion with arguments on both sides. So all this is to say, if the president were charged in court, in federal court, as he might be, the U.S. attorney in D.C. said that all actors involved in the January 6th riot would be examined for possible prosecution, including the president, and he can be charged after he leaves office. It's not, you could make a strong arguments on, well, I won't characterize whether they'd be strong or not, but you can make arguments on both sides about whether or not it would meet the legal standards for incitement. But an impeachment doesn't have to have a crime. You can impeach for conduct that constitutes a high crime or misdemeanor or gross. Inciting insurrection against the United States might be impeachable. And I think I'll venture to say the framers would believe that it was impeachable, even if it didn't meet the technical violations for the crime. You'd still have to make a judgment about whether you think that this president did incite insurrection in a way that rose to the level of an impeachable offense. But that's the state of play there. One final question. I said the president could be indicted if he, after he leaves office. That's assuming he doesn't pardon himself and the courts don't uphold a self-pardon. And the question of whether the president can pardon himself is also an open question because no president in US history has attempted to pardon himself before. Again, there's a very good We the People podcast on that question, where our interactive constitution scholars on the pardon power argued both sides, and they said it was a close case, that basically the text and history don't answer the question because the framers didn't expect presidential self-pardons. The basic argument against it is no person's a judge in his own case, and it's an affront to the rule of law. If the president, can incite insurrection and then pardon himself, then how can you ensure that the laws forbidding incitement of insurrection are upheld, and that the democracy of the United States is protected against those who would undermine it without consequence? The argument for self-pardons is there's no limitation in the clause, and historically the pardon power has been said to be unlimited. The British history is really relevant too. I'll stop here to whet your appetite to listen to the podcast, but that's the gist of the arguments on both sides of self-pardons.
So, Jeff, and we only have about 5 more minutes. And so I was telling him that you were sneaking in landmark cases with Brandenburg as we went through this discussion. And I will send everybody everything on landmark cases so you can review. And if you can come on Wednesday, that's great. But I guess the one question for the students that are listening is and I know you try to answer this in the beginning, but you really can't. But what do we expect to see during the course of this week? And I'm sorry that I'm making you the magic 8 ball to kind of guess for us what we're seeing. How fast do you think it's going to move? And we have in next week's inauguration. So, what are we seeing that's happening in DC at that time and all those pieces? Anything you can kind of say on the event horizon for constitutional questions that we could see come up?
Yes. The House tomorrow is likely to vote on a resolution calling on the vice president to invoke the 25th Amendment and remove the president. It appears the vice president will not take up that suggestion, in which case the House on Wednesday may well vote articles of impeachment against the president of the United States of America. And remember, that only takes a majority vote, although some Republicans have said they will sign on, and the question of how many will be quite relevant in deciding what kind of support begins to build in the Senate. After that, the question is how quickly the articles would be brought to the Senate. Would it happen before or after the new president is sworn in on January 20th? And there are also significant questions about legal cases being brought against individuals who were part of the insurrection last week, as well as further debates about the decision by the platforms to block the president from their platforms. And friends, as you evaluate each of these crucially important questions, I want you to read the news, please, closely this week, because it's important to keep up to date, but do so with a sense of historical context and constitutional thinking. I am not, the question is not, how do you feel? The question is not, what's your personal reaction to these events? Your responsibility as students of the Constitution is to look at previous cases that can cast light on whether or not the Constitution and laws are being violated, and to try to separate your politics from your constitutional conclusions. You might conclude that you think that what President Trump did was seditious, violent insurrection, but nevertheless it should not have been banned from Twitter, and that the platform should not be in the position of removing the leader of the United States of America from the internet. And indeed, Chancellor Angela Merkel of Germany today just said that although she deplored the president's conduct and thought it was insurrectionist and seditious, I don't know if she used those words, but suggested that she thought Twitter should not ban a public figure like the president. So separate your politics from your constitutional conclusions, think deeply, read lots. When I said read the news, that's just the start of your job. Then you've got to dig into the case law and pick one of the many questions that we've talked about today. Can a second impeachment be tried after a president's left office? Never been tried before. People are beginning to write about it. The Washington Post had an interesting roundup of scholars on both sides of the question. Read the scholarship, decide what you think. A good class assignment would be to write a short memo or have a debate about it, and take both sides of these cases, because they're so open-ended. You can argue both sides. Presidential self-pardons is another one, and as is the question of what's the standard for incitement. I hope you'll find the We the People podcast to be a helpful guide. We had the discussion between Dean Chemerinsky and Judge Ludig was very powerful. And this week we're going to have Judge Michael McConnell and Christina Rodriguez from Stanford and Yale Law Schools debating some of these questions. And always let's be calm and grateful that we live in a democratic republic where the US Constitution does provide a framework for the resolution of these contested questions. And also let us be grateful that the US Constitution, under the greatest test that any of us alive today has experienced so far, is carrying us through.
Thank you, Jeff. I know we're in unprecedented times how you tee this up, and we need to have these dialogues and discussions, and we need to make sure that all of our students are able to talk about what's happening in our country and answer those questions. So if those questions pop up for our teachers, for our lifelong learners, or for our students during the course of the next couple of weeks, please know that the NCC is here for you. Shoot us emails. You have my email address. You can always go to education@constitutioncenter.org. I believe, Jeff, you can just do CEO@constitutioncenter.org. We'll help you out. That's what we're here for. We're here to answer your constitutional questions, and they don't have to be perfect. You can just send them our way, and we'll get you the information on them, because we know sometimes it's a lot to go through. And we're right. We need to be engaged and energized in this democracy, in this republic, and that means asking those questions for understanding as well. So thank you guys very much. Jeff, thanks for getting us up to speed, going through all the pieces. And if we're going to go over landmark cases on Wednesday at 2, but I can connect you guys with all the materials so we stay current in our Constitution, because it matters, and get our historic foundation straight as well. Thank you, Jeff.
Thank you, everyone. Thank you, Curry.